All right. So good evening. Thank you for joining us today for Artists' Rights Online with Pro Bono Students Canada. We will begin shortly, but before we do, my name is Rachel Andrzejczyk, and I am the Training Programs Manager at Creative Manitoba. Creative Manitoba is located on Treaty 1 territory, the original lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and on the homeland of the Métis Nation. We are joined today by four soon-to-be lawyers: Ramsey Hall, Gavin LeBeau, Luke Young, and I forgot how to say this, Mikhail Sokolowski. I'm sorry. Also joining us is supervising lawyer Andrew Buck. Today we are going to talk about your rights online as an artist. If you have any questions throughout the talk, please pop them into the chat box either on Zoom or YouTube, and we will get to them at the end of the presentation. So with that being said, I will pass the mic over to Gavin.
Okay, hi everyone. Yes, so as Rachel said, my name is Gavin, and I'm just going to start us off. So we prepared a presentation about artists' rights online. This is just a disclaimer saying that we are not lawyers and this is not legal advice. So the agenda for today's presentation, first we're going to talk about some general rights in relation to like copyright, trademarks, and then talk about a little bit about fan art. Then we're going to discuss how putting this work, these types of work online can impact some of those rights, and then how to protect yourself. And then finally, we're going to go over some terms and conditions from different websites, and we'll kind of show you where to look and like what to look for. Okay, so copyright. So copyright is the exclusive legal right to produce, reproduce, publish, or perform an original, artistic, or dramatic or musical work. So these include, as I have on the slide here, things like books, pictures, films, computer programs, plays, like also all sorts of different types of things. So general rules of copyright. So owning the copyright for a work means that you have the exclusive right to commercially benefit from its use. So this includes it. You can prevent people from copying your work, modifying it, selling it, performing it, publishing it, or converting it. So if someone wants to use your work, they have to acquire the right or get your permission somehow. So how do I obtain a copyright? So there's kind of three things that you need to concern yourself with. If it's original, fixed, or if it's an expression of ideas. So original is pretty self-explanatory. It just means that the work must be a result of your own creativity. So you can't copy someone else's work. For expression, this is a little bit, because this can get confusing. So it's an expression of an idea, not ideas by themselves. So for example, if I wrote like a specific story about a book who lives in the jungle with wild animals, I have the copyright for that specific story and how I chose to express it. This doesn't mean, though, that I own the idea about a boy who lives in the jungle. For fixed form, it just means that you've done it on something like paper, video recording, audio recording, hard drive, memory card. You fixed it to some tangible thing. So in Canada, an original expression of an idea is automatically protected by copyright upon its creation in a fixed form. So that you don't have to do anything. You just make the work and it's done for you. However, if you choose, you can apply to register your copyright. This kind of allows for more robust protection, especially if you're required to prove ownership of the work in a court of law, but is not required. So term and duration. So how long does it last? So in most cases, copyright lasts for the life of the author and for 50 years following the death, starting at the end of the calendar year. So that means protection would expire on December 31st of the 50th year after the author passes away. Can you lose a copyright? So, because we're talking about posting it online. So posting your work online does not mean that it's in the public domain or it's free for anyone to use. However, most websites have provisions in their terms and agreements that allow them to use your work in some capacity. So therefore, it's critical to read these user agreements and terms and conditions before posting any work online. This is kind of what the whole presentation is about. just as a side note, so public domain, if people are curious what that means, it just means that the work is available for anyone to use and copy without seeking permission from the copyright owner. So this would maybe apply to things that like the author had passed away and it's been 50 years since then. Just as a side note for that, different versions of something can still have the copyright attached to it. So for example, like Alice in Wonderland is in the public domain as the original author had passed away over 100 years ago. However, like Disney may own the copyright to the specific portrayal of that character in their movie. So even though like Alice in Wonderland as a whole is like in the public domain, like whatever version that Disney or whoever came up with something, they might have the copyright for that specific portrayal of that character. So you could still be infringing someone's copyright if you posted something like that. So this kind of ties into the next part of it, which is fan art. So does copyright apply to fan art posted online? This was like a very interesting thing for me because you see fan art online all the time, and it's like I've wondered like if this was something that was legal or like if people are just not getting in trouble. So as a general rule, if there is copyright, the distribution display of any rendition of that work is subject to copyright infringement. So yes, copyright does apply to fan art posted online. Because it's so rampant online, there's quite a few like misconceptions about whether this is allowed and whether this is illegal. So the first one is if it's not copyright infringement, if there's no profit. So this is false. So the absence of profit does not automatically exclude fan art from copyright infringement. It can play a factor into like strengthening an argument around fair use or fair dealing or fair use, if that's what it's referred to in the US. This presentation we're not going to go over exactly what fair dealing is, but basically it's certain circumstances where a person may use a copyright protected work without permission. There's another document on the Creative Manitoba website that PBSC students worked on it last year that deals with that in more detail. So if you're interested in that, you can go look in that and see and learn about that. The next misconception is that it's not copyright infringement because everyone else is doing it, and so there's no consequences. So yeah, despite the fact that it is extremely common, posting or sharing up fan art can still be a violation of copyright. Reasons for this could be just that the copyright holder just is looking the other way when it comes to like non-commercial fan art, or that they view that it's not maybe worthwhile to go after every single person that's doing this. Or there's even copyright holders that welcome fan art because they think it has a positive effect on their property, that it creates like goodwill for their fans and it's good promotion to reach further audiences. But like regardless of the reason, just because they allow some forms of the fan art doesn't mean it opens the door for everything else. So the copyright holders still might subject you to saying that like fan art that is like racist or overly obscene, that like that's not allowed. The bottom line is that if you do not have permission from the copyright holder, posting or selling fan art is copyright infringement, and they could pursue legal action at any time. The caveat would be like that non-commercial fan art is less likely to attract attention, but commercial exploitation, so selling it, especially like on a larger scale thing, it can easily attract legal consequences. And this can be true even if you've engaged in the activity for years on like depending on what platform, whatever, it doesn't mean that they won't eventually come after you. So you should just be aware of those consequences. Okay, so what are my options? And if I'm not allowed to do this, so you could always ask for permission from the copyright holder to sell that fan art and to sell the merchandise associated with it. It's completely possible that the right holders will just refuse you permission or just simply ignore you, in which case you can't do it. Another option would be to utilize partner programs on websites like Redbubble. So this allows you to create and sell officially licensed fan art for select brands. I will say that if you submit any artwork to this partnership program, you are automatically entering like into a legally binding contract with the website, and you're thus agreeing to their terms and conditions. I'm just going to quickly switch over my screen. So like this is, if you go to Redbubble and they're like help center, they have a thing on their fan art for like the partner program. So it kind of goes over like what's required and like how it works. So you can check their brand partnerships. So these are like the different types of the brands that you can want to work with. So if you wanted to do like something from Adventure Time, you click on it and they have kind of guidelines of what you are allowed to do and what you're not allowed to do, which you have to kind of follow. So then once you've done all that thing, you tag your work and you apply, post it, like you submit it to them and they'll look at it, review it, and then email you saying that like, yes, you've been approved or no, you haven't. And if you have been approved, then you can start selling whatever fan art you have and like the products associated with it. So this is just one way that you could legally sell fan art without worrying about like legal consequences. And it's not just exclusive to Redbubble. There are a bunch of other like websites that offer this as well. So I'm just going to go back. So I'm just going to pass it now on to Luke, and he's going to talk to you guys about trademarks.
Hello, everybody. My name is Luke. I'm going to talk a little bit about trademarks, what their purpose is, how to apply for a trademark with the Canadian Intellectual Property Office. That they're where you submit your applications most of the time, and they sort of govern the whole trademark application process and everything like that. So the purpose of a trademark is to identify a product or service, and this trademark can be anything that identifies the product or service, whether that be a group of letters, words, it could be a design, it could even be sounds or a sound. I'd say for the purpose of artists' rights online, a design for people that own businesses that want to make their own logos or something, that would be probably somewhere that you would consider filing a trademark. So these trademarks are granted by CIPO, the Canadian Intellectual Property Office. And after 10 years, they can be renewed. They could also be amended if you want to add something, take something away. If you want to just change something with your trademark, so you can amend it. There's also the option of opposition, which is if you see somebody filing a trademark that looks similar to what you have or could potentially be confused, there is a mechanism to oppose this trademark. You can say, I think this is infringing what I've been doing. So I've got a link here to a website that has kind of a roadmap of where to go and who to apply to. Gavin, would you be able to share your screen? Thanks. Yeah, so it's from the Government of Canada, and it has just sort of a step-by-step list of instructions of what to do when filing for a trademark. First, you file it. They issue you a filing date and an application number. They look over it, make sure it's something possible to be registered, and eventually CIPO sends you back a report letting you know if there are any issues, if it's already infringing. You can respond to this report, and after that, it would either be approved or refused. So that's just the basic roadmap of application and applying for a trademark. And can we go to the next? Thanks. So with the Canadian Intellectual Property Office, it is cheaper. Listed on the website are the prices for the application. There are some fees that have to be paid and further fees for every other class of item that you file an application for. But it is cheaper to apply with CIPO. There are alternative ways of applying, but According to the website, it is cheaper. They have the instruction service, which I have shown, and they can do amendments, renew it after 10 years, and you can also file the statements of opposition, which I've mentioned before. Thank you.
Okay, so we've been talking about copyright generally. I'm just going to go pretty briefly over some things that are particularly pertinent to uploading your work or your art to the internet. The main advantage with the internet and uploading work there, or art or anything really, is that it's very easy to detect plagiarism. It's easy to detect if someone is breaching copyright or is infringing the copyright on your work. Obviously, before the internet, you'd have to hear about it from someone or read it in the paper or something. Here, you can just search using Google. There are even many image search functions like Google Image Search where you can upload your image directly there and search for exact matches. That's a really effective way of seeing if your image, if your piece of art is being used by anyone else. So that's a really big advantage to using the internet and copyright on there, protecting copyright. There are a couple disadvantages as well. The first one is that it's easier for other people to steal or to plagiarize from you. Just like you can search anything you want, so can everyone else, and they can come across your material, they can download it, and once they've downloaded it, they can do just about anything they want with it, not in terms of not legally speaking, but in practical terms. They can print off 1,000 copies of it and just post them all around the city. Now, some of you might be thinking, well, sure, it's easier to plagiarize my work, but you just said it's also easier to detect plagiarism. So surely I just go somewhere like internet.com, speak to the manager there, tell him my problem, and then he removes the offending material. Unfortunately, it's a little bit more difficult than that. There's not a simple mechanism like that, generally speaking. So that brings us to the second disadvantage for uploading art and other intellectual property or copyrighted materials to the internet, namely that it can be hard to enforce copyright laws. Let's say you find a piece of your work or art being used in violation of Canadian copyright laws. One problem is that the person who's infringing your copyright, they might not have a face and they might not have a name. A lot of people are completely anonymous on the internet. Even social media, it could be a pseudonym or something like that. It's not necessarily their real name. And if you don't have that, it's going to be very difficult for you to get them to take down the copyrighted material. The second reason why it's hard to enforce copyright laws is that if the person isn't from Canada, I mean, if they're infringing a law in another country, generally speaking, that country's laws will take effect. But there are some exceptions to that. There are also international copyright standards, but it's important to note that these are pretty outdated regarding uploading stuff to the internet. And they're also often pretty minimal. So something that may infringe copyright here in Canada won't necessarily infringe copyright according to these international standards or to another country's standards if they're not party to an international agreement. So in conclusion, basically, you can, I'm sure everyone who uses the internet or has used, everyone's used the internet, but we often hear that if you put your stuff online, it's going to stay on there. You should consider that it's permanent. Even if it's deleted, even if you try your hardest to scrub it completely from the internet, somebody somewhere might have saved it. So that's the important part of this, is just always keeping it in the back of your head that if you put something up there, it's not necessarily going to be easy to remove it ever. And I think I'm passing it over to McCall now.
Perfect. Thank you, Ramsey. So considering those cons that Ramsey mentioned previously, I'm going to give you some ideas on how you can protect your content online. So one thing that you're likely familiar with is that you can put a watermark on your content. So if you have any pictures, art, anything like that, you could just put a watermark on there that will help make the content less desirable. So I won't go into too much detail regarding this because I'm sure that most you're aware what it is, but essentially you just put an opaque image over your image so it is less desirable for people to use. An alternative for this is that you can also put text somewhere on the photo. This may cause issues though, that it would be easy to crop out this text And so a watermark might be a better option. Another option is that you can be the gatekeeper of your own content. So rather than posting your content on the masses, so posting it to anyone that could see it, you can put some samples of your work online and have people that are interested in your work just reach out to you directly. That way, then you can decide who receives more, see if they're credible, see if they have a sketchy email, something like that. So this will allow you to control who gets to see your work and limit those who are interested in your work rather than have it be viewed by anyone on the internet. Next slide, please. So another thing that you could do is you can control who sees your content. So several websites have options where you can set your account to private, or you can send direct links to people that want to view your content. As an example, on Instagram, you can set your account to private and approve or deny follow requests accordingly. Another example is on YouTube. You can set your video to private, only allow people who have the link to the video to see it. These methods would make it so you can decide who or who is not allowed to view your content, which is very desirable. Something that Ramsey also mentioned earlier is you could also be notified when someone uses your work. So if you have a Google account, you can set up a Google alert to notify when certain phrases or keywords appear on Google. As an example, you can set an alert for something like John's Art Studio that will notify you when that phrase appears in a Google search. Like Google Alerts, you can also reverse search written material or photos to see if they appear on websites. So on the website CopySpace, you can input your web page to see if there are any duplicates of the written work on any other websites found throughout the internet. Similarly, on the website TinyEye, you can reverse image search by dropping an image on the website, and it'll give you all the websites where that image exists. So now talk about more specific websites, specifically starting with YouTube. Next slide, please, Gavin. Thank you. So on YouTube, the creator or poster retains the ownership of their content. YouTube is granted a license by you posting your video on their website that they in turn host and allow the video to be shown around the world. The creator is free to remove their content from the website at any time. Generally, the video will remain on YouTube until the creator removes the video themselves. YouTube also reserves the right to remove any content that is posted on the website that they feel is in violation of their guidelines. Although it is against YouTube's community guidelines, other people can download the video off YouTube from third-party websites, so keep that in mind whenever you upload anything on YouTube. Now we will consider YouTube's dispute mechanism. So YouTube recommends that creators should only upload videos that they have made or are authorized to use. However, with the amount of content that is uploaded to YouTube on a daily basis, it's very difficult for them to remove any content that they find is in violation of copyright. In terms of dispute resolution, YouTube has a copyright claim system that users can submit a claim to when they think that the content found on the website falls under one of the following categories: is inappropriate, the person appears without my permission, is abuse or harassment, violates privacy, violates a trademark, violates copyright, or other legal issues. The interface of this claim system is pretty easy to navigate, and it is really user-friendly. So if you do think something on the website falls in under the issues that are mentioned previously, it is recommended that you do file a claim. But however, it is noteworthy that this claim system does take a while to go through. A final notice on YouTube is regarding fair use. Fair use is a US law that allows certain copyright protected material to be used without getting permission from the copyright owner. This is determined on a case-by-case basis. So work that is considered fair use includes commentaries, criticisms, research, and teaching or news reporting. So I'll now briefly consider Twitch. So Twitch is pretty similar to YouTube, and you'll see that with a lot of these websites that they have really similar kind of copyright frameworks to each other. So on Twitch, similar to YouTube, the content creator retains the ownership of their content. Twitch acts as a licensee that distributes the content throughout the world. In other words, Twitch does not own the content, they merely distribute it. The content creator has the right to remove their content from the website at any time. Twitch also has the right to remove any content they deem inappropriate or harmful. Like YouTube, third parties can also download content that is on Twitch and distribute it accordingly. This often happens when a Twitch user's content is uploaded to another video sharing website like YouTube. In this event, or others similar to this, the user would have to contact YouTube to get the video removed. So Twitch also has a takedown mechanism similar to YouTube. So if you think that Twitch user has used your content without your permission or infringed on your copyright, you can contact a Twitch copyright agent by email at dmca@twitch.tv and provide them with the following information: identification of your work that is being infringed on, identification of the Twitch user's work that infringes on your work with a link and timestamp, and statement that shows that you in good faith believe someone infringed on your copyright and that the information provided is accurate. An important thing to note about Twitch is because the content on the website is mainly consumed in real time, this takedown mechanism may not be effective. This is because most viewers would have already seen the video that may have used your work before it gets taken down by Twitch. So now I'll pass it on to Ramsey, who will talk about Tumblr.
So we have a lot more websites on the document that's uploaded to the Creative Manitoba website. So we're not going to do all of them because it'd be repetitive and it'd take too much time. We just decided to highlight Tumblr as one of them because it's representative of a lot of image sharing sites. The framework for all of these is basically the same. Another really big one is Flickr. The basic idea is that you retain all rights to all the work that you upload. But that, of course, doesn't mean that others can't or won't do things with your work. One of the important things to note about Tumblr and a lot of these other websites is that they're very social websites. It's an important aspect of them. So the default scenario for a lot of these is that all the work and anything you do, anything you upload will be automatically shared publicly. So if you want to stop that, you have to take steps prior to the initial uploads to make this, to turn your settings to private. And even again, just to reiterate, even if you do things, send it to private, switch it to private, you know, people can still, that you send it to, they can still download it, they can still share it publicly, right? So just always keep that in mind. It's limited privacy, it's not complete privacy. If you do find that your material is being used without your permission in a way that you don't want it to be used, you can submit a notice under the DMCA, which is the Digital Millennium Copyright Act. And Tumblr has staff and they'll have a look at your claim, and if it's legitimate, they'll remove or disable access to the material. And they'll notify the user as well that they made a copyright infringement. So that's just a really brief overview of Tumblr and all of the image sharing sites, all the sites where you upload photos or drawings or any kind of static art. Now over to Luke, I think.
Thank you. Yeah. So I just wanted to give a brief overview on e-commerce websites such as Shopify and Etsy. They are, to put it simply, websites where you can sell things. Etsy, I know you can upload crafts, clothing, I believe artwork as well. And I think Shopify is just about the same sort of stuff. Next slide, please. Thank you. So as to who owns the content that you upload, if it's on Shopify, you own the content, but Shopify has the right to take it down if it goes against their terms of service. On Etsy, you also own the content that you upload, and by uploading it, you grant the site and Etsy, you grant them a license to reproduce this or promote it. So when uploading, you are responsible for your own content and has to make sure that it's not breaching the terms of service or infringing on anybody else's rights. Make sure it doesn't copy somebody else's artwork that you're uploading or something like that. As for takedown mechanisms, if you notice that, say, somebody has uploaded something that you believe to be infringing on something of yours, Shopify has a DMCA notice and a 14-day period where they will, upon being notified, they will take down the infringing artwork or infringing item that has been uploaded. They will take it down for about 14 days. Within those days, you can file a court order if you need to. And they have the link there to do it. I believe you have to log in for that. Etsy has a similar policy in their intellectual property policy they have it in significant detail there. But basically, you just use this reporting form, and they will give notice to the person who you are reporting. They will remove it, and this person who has their artwork removed or who has their infringing content removed may be able to file a counter notice where they try and justify it or state that they are not removing or not infringing. But it's more or less the same thing with a period where it is taken down temporarily. In that period, you can file a court order if necessary.
Okay, so before we kind of get to questions and conclude, I just want to show everybody there's a website here. This is not affiliated with us or anything, but I stumbled across it, and I just thought it would be a useful like resource to start learning about terms and conditions. So I'll just share the screen for this. So this is like terms of service TLDR, so too long didn't read, and it just has like a list of like some websites about like, and it rates them on like their terms of conditions and how like invasive they are on your privacy and like a bunch of other things. So like YouTube, for example, has a grade E, which is not very good, and it kind of goes into detail of like what are the negatives or positives about the website. So like this service can license your content to third parties, or this service can use your content for their existing and future services, for stuff like that. And you can click on it and it will take you to like the quote saying like, by providing content to the service, you grant to YouTube a worldwide, non-exclusive, royalty-free, sub-licensable, and transferable license to use that content, including to reproduce, distribute, prepare, etc. So like, this is just like a good starting point. You can go, like if you go to YouTube and you click on their thing and you go to the bottom. So usually their terms of services and like privacy policies, all that stuff is usually at the bottom of the website. So if you click on terms of service for YouTube and you can scroll down and you can find here, licensed to other users. So like you can find that exact quotation that was taken from the website. So you can just like confirm, just because this website might have gotten it wrong or something like that, but it's just a good starting off point. And it has like, you can search other websites. It's not just like YouTube. It has a lot of the big websites and some of the other smaller ones. So this is just another resource that you could use if you wanted to check some of the terms of service without having to maybe go through like the entire thing, because I know some of the documents can be quite long. But yeah, I think that wraps up our presentation. So if anyone has any questions.
Thank you. That was awesome. I don't see any questions in the chat. So if anybody has questions, you can throw it in the chat. Sorry,
I can put the link for this website too in the chat too, if people wanted to click on it and look through it.
that'd be really awesome. There's also the opportunity for you to be unmuted to ask your question. Just let me know in the chat if you want to unmute yourself. I'll have to do it myself. Just know that we are streaming to YouTube, so if you are comfortable with that, you can ask your question aloud. I don't know if there are any takers. Well, I have a question then. It's kind of awkward because I know like legally there's, it's always like, yes, everyone can, like uploading anything online, people can steal it, right? And that is legally the reality. But I don't want people to be scared of uploading any of their work online, because it is kind of in this day and age, a necessity as an artist to kind of have your work out there. So I guess my question is, what would you suggest to somebody who is scared they're scared to post any of their art online. I guess, what is the probability of getting sued and losing a bunch of money? You know what I mean? The fear that's there.
I mean, well, if you're the one that's uploading it, you're not, I don't think that you're at any risk of being sued or anything like that. It's more about you protecting, about you not wanting other people to use your work in a way that you wouldn't like.
Right.
So you're just by uploading anything, you know, unless it's very offensive or something like that, there's no chance that you're going to get sued just by uploading.
Yes, that's true.
And also, I mean, I could just add like a little story I was thinking about just today when I was thinking about the presentation. There was a band, I don't remember the name. Like the point of the story is that there's a lot of positives with uploading your work, and even if it ends up being taken by people without you knowing. There was a band, a Canadian band that became very popular in Russia about 10 years ago, and their music was pirated off of LimeWire, I think, and they didn't know about it, but they just somehow heard, and there's this huge following of Russians that loved their music, and they didn't even know about it for a really long time. So even if someone does take your work and you know they're essentially infringing your copyright, you know, all publicity is good publicity, right? In a way. I mean, that's not necessarily true all the time, but there are positives, there are positive aspects of people being easily capable of taking your work. You can get famous, you never know.
Right.
I also add to like if like you're posting like artwork or stuff like that, I know like some of the communities are depending on the size of it, but they're very supportive of each other. And so like if someone like another artist noticed that like someone else is posting an art that they recognized from like someone else, that they would contact you, or same with fans and stuff like that too. If they notice that someone is stealing someone, that they would tell, and then usually that person is like ostracized or whatever, that this person is known to be like stealing content or stealing artwork and stuff like that. So I feel like the community does like help protect like among themselves. So I think that's really cool.
Yeah, and it's good to, I guess, in my question when I was saying for fear of being sued, is that like most art is copying in some way. Like you learn by copying other art, and yeah, but as you said in the first like 5 minutes of the presentation, it's not the idea, it's the what is it?
It's an expression of the idea. It's how you
expression.
express it. Yeah.
Yeah.
Also, just noting about that too, because when I was researching about fan art, a lot of the stuff happens in the States and stuff. But I was watching a presentation that someone did about fan art, because like if you wanted to draw like for comic books or something like that, like some of the requirements to get that type of job is to be able to show that you can draw the artwork, which is like whatever Marvel, DC, or whatever it is. And so you have, in order to be able to do that, you kind of have to be able to practice and show off your work, that like, look, I can do this. And so then you are kind of infringing the copyright in that sense, but then it's also a prerequisite to get the job. So it becomes this very like gray area.
Cool. I'm hoping we get at least one question from somebody in the audience. I see you. There's nine people here. Awkward silence. What were some other interesting things that you read into? I remember watching this documentary called Rip, a Remix Manifesto, about the DJ Girl Talk, and how he like you know samples a bunch of songs, and it's like totally illegal, but somehow he gets away with it. Did any of you kind of research that, like the music side of things? And
I don't believe we did music. I
no.
don't think that was something that any of us focused on. No.
Yeah, pretty interesting. I think there's a culture of of letting people yeah, like you said, Ramsey, of like the popularity of something kind of surpassing the amount of effort it would take to see somebody over it. Yvette, I'm sorry I missed the majority of the talk. That's okay, Yvette. You can watch it later. Okay, well, if there's no more questions, I think I'll stop my rambling and we can call it a night. So thank you for your presentation. It was really awesome. And the document that the students created for us is on our website. I'll link to it. And that has more information on different platforms, correct?
Yeah.
Yeah, and it just goes more into detail of kind of what we discussed as well.
Very cool. Okay, well, thank you so much.
It looks like we do have one question.
Oh, perfect. Go ahead. Oh, I have to unmute. Allow to talk. I believe you need to unmute yourself.
I think he asked the question in the chat there.
Oh, got it.
I can answer this if that's all right. So the difference between a patent and a trademark is a patent is typically for inventions. If somebody invents, I'd say a very common one is pharmaceutical drugs. That's been a big one. But if somebody invents something to solve a problem or fulfill a purpose, and if this invention is new, hasn't been created before, that would be the kind of situation where they would look for a patent. And a trademark is more something to identify the company that selling a product or selling a service. Yeah, so like a trademark would be more like a logo or a jingle, something that you would associate with a company or a product, whereas a patent would be the protection for your invention. Yeah.
Oh, there's one more question. Can workshops be trademarked or protected? I think Yvette's talking about like a workshop like this that you present. Can you patent that?
I don't know. Do any of us know, or should we maybe ask Andrew to answer that one?
Yeah, sure. I'll chip in here. So I think what I would say is a workshop is not a patent because it's not an invention. I don't think you could protect it under a trademark because the trademark is going to protect the goodwill associated with a brand or a slogan, etc. So maybe if you've got a series of workshops that you're protecting, you could protect the name of those workshops, or if you had a particular logo via trademark, but it wouldn't actually protect the content itself. If you were getting into actual written content that was delivered or performance that was delivered at a workshop, then that might well be something that's subject to copyright. The specific processes or skills that might be getting into ideas, and as the panelists have discussed, you don't protect ideas, you protect a particular expression. So the idea of a skill or a process, that's not something you could protect. But if you had a particular manifestation of how that works, like a step-by-step instruction guide, for example, that might be something that you could protect as a literary work through copyright.
Cool. Thanks, Andrew. If there are no more questions, last chance. I think we'll end it for today. So thank you so much for your time and for sharing that knowledge. Maybe if you could send me the slide deck and I could send it to anyone who is in attendance, if you're comfortable with that. And yeah, good luck with your finals coming up.
Yeah, no problem. I can send you the slides.
All right. Everybody have a wonderful evening. Thank you so much.
Thank you.
Yeah,
Bye.
thank you.
Thanks.